Welcome to the San Mateo County Dental Society webinar. Looks like we have a really good audience for tonight. My name is Brad Hart. I'm the 2021 Zoom president of San Mateo County Dental Society. Before we get started tonight, I want to review how we'll be running this meeting. All participants will be placed on mute. Our presenters will be providing a presentation on risk management, informed consent dismissals, and refunds. During the presentation, you may post a question in the Q&A. For those participants on a desktop, the Q&A box is located on the bottom of your screen. For those of you on an iPad, which I am tonight, or an iPhone, the Q&A box should be in the upper right corner. Please feel free to post your question, and at the end, if time permits, we'll go over them at the end. So now, let's get started. We have two presenters tonight. Our presenters are Jessica Saetern and Jamie Wiles, TDIC Risk Management Analyst. Jessica joined TDIC as a risk management analyst in 2019. She supports the dental professionals through national speaking engagements at major industry events, virtual presentations, and dental conventions, dental schools, and state dental societies. She brings over 10 years of dental experience in the area of insurance billing, claims management, provider appeals, and as a business consultant, Jamie joined TDIC as a risk management analysis in 2019. She has served as an advisor for the dental profession in the areas of professional employment and business liability risk management. Mrs. Wiles has over 20 years of experience in front office operations, dental equipment sales, technical support, and customer service for leading dental equipment suppliers and distributors. Please welcome Jessica and Jamie.
Hello, everyone. Thank you, Dr. Hart, for the warm welcome. And thank you for your patience for me trying to get this PowerPoint up. My name is Jessica Saetern. My colleague, Jamie Wiles, and I are excited to present on this important topic today.
Hello, I'm Jamie Wiles, and we appreciate you taking the time out of your day for this presentation.
Before we begin, we would like to go over the webinar components. We will be taking questions pertaining to the topics discussed through the Q&A feature. Please type in your questions the way you would like for them to be read out loud. As questions come into the Q&A feature, our risk management panelist, Taiba Sulaiman, Senior Risk Management Analyst, will be behind the scenes responding to questions in the Q&A feature during the presentation. Selected questions will be answered live. Please know we will address as many questions as we can within the time remaining.
After this presentation, you will be able to establish a comprehensive informed consent protocol, determine when and how to issue a patient refund, and learn when it may be appropriate to dismiss a patient. What is risk management? Risk management is the practice of identifying, analyzing exposures to loss, and taking steps to minimize those exposures. Incorporating risk management into a dental practice means being disciplined and continually determining which issues are important to deal with and dealing with them right away, implementing policies to address those risks. Another way of incorporating risk management is documenting informed consent forms and other discussions with patients. Using informed consent forms as an example, risk management means assessing potential issues before treatment. For example, practicing thorough informed consent with all patients may help alleviate potential problems. Be sure that patients are made aware of risks, benefits, and alternatives before beginning any procedure, and document that conversation in the patient's chart. An informed consent form may be used to supplement the discussion, but never to replace it. If a form is used, keep the signed original in the patient's chart and give the patient a copy. It will be difficult for a patient to allege that they were not properly informed when the documentation shows otherwise. I'd like to turn it over to Jess.
Yes, hi, I'm back. Sorry about that. It looks like I dropped off. All right, so I like to go over how proactive and reactive measures ties into risk management. Remember, you can only control so much, such as the patient's perception of what you can and will do. Being proactive is a form of problem solving before the problem arises. This requires some critical thinking to identify problems and solving them before there is a problem. For example, a patient who continuously refuses to follow your treatment recommendations. This proactive approach to consider is if you want to continue maintaining this patient and if dismissal may be best. Some of you may be asking, well, what about informed refusal? Is having a patient sign an informed refusal considered a proactive approach? Well, not necessarily. Depending on the circumstances, dentists should be aware of continuing to treat when the patient's refusal jeopardizes the possibility for a successful outcome. In any case, a patient's refusal should be thoroughly documented in the chart, along with the dentist's attempts to inform the patients of the consequences. Every situation is different, so when in doubt, call the risk management advice line.
Thank you. That's a good
Mhm.
example, Jessica. The opposite of proactive is reactive, which addresses the what now mentality when a crisis happens. Reactive means it's now too late to avoid a problem. The problem is here and now you must react. Sometimes the outcome is good and sometimes additional mistakes can be made because there's no time to think the problem through first to determine the best solution. Reactive measures foster crisis-based thinking, require finding a solution after the problem develops, which then limits treatment options and/or solutions. So what's an example of reactive risk management? Let's say you extract the wrong tooth and didn't realize it until the patient had already left the office. Maybe you were in a rush that day, or maybe you weren't looking at the right patient's x-rays. Whatever the reason, you must tell the patient. When you call to tell the patient, the conversation doesn't go very well. The patient calls you later in the week, very upset, and demands not only a refund, but that you pay for claim and suffering, as well as an implant and crown to the dentist of their choice. This situation is an example of a reactive state, leaving you limited options to resolve the matter. Now, viewing it from the proactive measure perspective, before extracting, take time out to review your patient's chart and ensure you're looking at not only the right patient, but the right tooth number and x-rays. Using the timeout method is extremely helpful in being proactive. We will be viewing a short video later in the presentation that addresses the timeout method.
Now that we have gone over the difference between proactive and reactive, I want you to focus on some of the ways you can manage risk using proactive measures. To list a few, use informed consent forms, use visual indicators to keep things consistent, use office huddles and meetings to foster opportunities for communication. And so back to what I was mentioning, to list a few of the proactive measures, strive for consistency in the office. Reinventing the wheel each time you do a procedure can lead to errors. So being consistent is a proven effective way to doing things. During this presentation, we are going to discuss how you can manage risk by a proactive approach to common issues you may have experienced, such as informed consents, refunds, and dismissals.
Okay, here we have our first poll question. Which of the following do you encounter most in your office? Patients not asking questions about the informed consent forms, unrealistic or unreasonable refund request on sound treatment, or a hostile patient that you've dismissed, but they just won't go away? Okay, it looks like most of you have selected C. We will go through each scenario and provide guidance on how to manage these situations.
But first, we are going to listen to a call example of a proactive approach and evidence that even experienced dentists have concerns about how to mitigate risk. The Risk Management Advice Line is a service offered to policyholders and association members where dentists can receive advice concerning patients and employment issues. To give you an idea of how many calls are handled, the Risk Management Advice Line received 18,018 calls in 2020 from policyholders and CDA member dentists. Let's go ahead and listen to the call now.
The following call has to do with communication between the dental team and a minor patient's parents. While you are listening, try to figure out what went wrong and what should have been done. The end of the call will have advice the analyst gave.
TDIC Risk Management, how can I help you?
Yeah, hi, I'm a prosthodontist and I need to talk about a situation that happened in my office.
Great, I can help. What's going on?
Well, a father came in with his 17-year-old son for an implant consult. The patient had orthodontic appliances on. I examined him and found the area Dad was referring to, plus another area where another tooth was missing with a space maintainer there. I mentioned this to Dad, who knew nothing about the second area.
Oh, just a moment, doctor. Let me ask some questions so I understand. A patient was referred to you for a single implant consult?
Yeah.
Okay. Who referred, the general dentist?
No, the orthodontist. I've worked with him a few times over the years.
Is there a general dentist?
I'm not sure.
Okay, so the orthodontist referred the patient for a single implant consult, but you found two areas where teeth were missing. You pointed it out to the father, who said for the first time who said this was the first time he'd heard of the two missing teeth?
Yeah, he asked what he should do. I told him that considering the location, closing the space with orthodontia is an option, but the ideal treatment would be placing two implants.
Hooey, I'm sure he was happy to hear about that.
No kidding. Actually, he got pretty upset. He said he would contact the orthodontist, then he left. I called the referring orthodontist as soon as Dad left to let him know what happened. He said that he knew about the missing tooth. He diagnosed one tooth to be extracted by an oral surgeon. By the time the patient got to the oral surgeon's office, that tooth had fallen out. Well, he looked in the patient's mouth and determined another tooth that needed to be pulled, so he did that.
Wow. No approval from the parents for this change of treatment plan and no call to the referring dentist prior to the extraction?
Yeah, apparently not. Subsequently, the dentists got together and created a plan for two implants. They would split the cost of the additional implant and restoration, but didn't tell the dad. I told the orthodontist how upset the dad was, and he said he would contact him.
Oh, have you spoken with the dad since then?
Yeah, he called me. He said that after he left a voicemail for the orthodontist, he received a letter from him. I did say that a tooth had been pulled in error, but the oral surgeon and he were working together to solve the issue. Then he started talking about how my son wasn't a good patient and had broken some brackets.
Uh-oh.
Yeah, the dad said it felt like a conspiracy and wondered if he would have known about the second implant if he hadn't come to me. He said he was thinking about suing the oral surgeon for pulling the wrong tooth. He wants me to take over the case.
Well, how do you feel about that?
Well, I can handle the case, but I'm uneasy since he's thinking about suing another dentist.
After hearing the case facts, what do you think this dentist should do? Dismiss the patient and ignore the dad's request because you don't want to get mixed up in this mess? Or explain that you can see how it got a little confusing. There was a problem and the other dentist did come together to try to solve the issue. The solutions they came to make sense and is not costing the parents any additional money. However, they did forget to include the parents.
Interesting call. Now let's listen to what the advice was.
Well, I understand why the dad is upset. From his viewpoint, it seems like the two practitioners were conspiring. My question to those dentists is, why didn't you tell the parents? Had they done that, there would have been no issue now. And I can see the practitioner's side. There was a problem, they decided upon a plan to split the fees, and that was it. Well, the missing link is no one informed the dad.
Does the patient being a minor have anything to do with it?
Well, one could argue that the patient could have told his dad about the wrong tooth being extracted, but the patient is a minor and you can't expect a minor to be up on which tooth is coming out and which one isn't. He arrived at the oral surgeon's office to get a tooth extracted and that's what happened. If you decide to take this patient, doctor, make sure you document where your treatment starts. Get a clear benchmark, take photos, models, etc. Keep the parents apprised of any changes to the treatment plan. You know, honestly, I don't think this is a case to shy away from. If you're comfortable with the plan, just be aware of the treatment history and be transparent.
Okay, great. That sounds good. Thank you so much for the help.
Excellent. And so let me know what happens, and if you need any other questions, anything else, just give us a call at the advice line.
Will do. Thank you.
If you have not called the TDIC Risk Management Advice Line, I hope this call gave you a little insight to the advice line offered through TDIC. Jamie, do you want to go over how to get a hold of the risk management?
Sure, Jessica. There are various ways of reaching the risk management advice line. You can call toll-free email, or visit the TDIC website to schedule a one-on-one 30-minute phone consultation. If you have a question or concern, you will be connected with a risk management analyst. TDIC's risk management analysts are available to assist you in exploring your potential options, providing solution-focused advice and topic-specific suggestions. Many dentists utilize this service, not only for advice, but also to talk through issues and confirm their actions. Just so you know, a call to the advice line does not constitute the reporting of a claim. All of our risk management staff have a background in dentistry. The beauty of this is that we understand what it's like to be in a dental office. Dentists are often pleasantly surprised that we speak their language. We know what a restoration is, and we understand the importance of occlusion. Some examples of why a dentist would call the advice line are problems with patients, problems with employees, responding to negative reviews, questions regarding consents, patient selection, treating minors with divorced parents, and dental board complaints. These are just to name a few, but today we're focusing on informed consent forms, refunds, and patient dismissals. I will now hand this back over to Jessica to discuss the importance of informed consent.
Thank you, Jamie. I want to ask our attendees today, how important do you think it is to have a signed consent? I am sure many of you know how important it is, but do you have the protocol in place for your informed consent process? One of the protocols before you start any treatment is stop and gather the proper informed consent for your patient. Informed consent requires the dentist to explain the likelihood of success and its risks, benefits, and alternatives. A dentist, not a staff member, must lead this conversation. The amount of time spent discussing options and answering a patient's questions depends on the level of risk. Higher risk levels and more invasive treatments are two indicators that more time and detail should be spent informing the patient about the risks, benefits, and alternatives of the treatment, including no treatment at all. Patients have the right to ask questions about the recommended treatment. A patient and provider successful relationship not only fosters support and trust, but also a common shared decision-making. An informed consent process is also part of documenting. Some examples of documentations are the nature of the recommended treatment, the risks, complications, and benefits of the recommended treatment, the alternatives to that treatment, including doing no treatment, and an explanation of the treatment plan's expected sequence of events. Common law has established that a patient has the right to decide what will happen to their body regarding medical care. There are two aspects to that law. One is consent, which is the right to consent or refuse to consent to treatment. The second is informed consent, which is the right to sufficient information to make that consent. Informed consent is a process and not just a form, but the form helps enrich the conversation and can aid in your defense. The consent process sets the foundation of the relationship between you and the patient. Some providers feel that consent process is just part of the day-to-day process, but think of it as an educational process. Thus, to simplify this, you're giving the patient equal right to choose and at the same time, educating them to make the informed decision. If you choose to write the informed consent entry, be sure to include the date, parties present, and issues discussed. It is recommended to note in the patient's chart, RBAs were discussed and patient consented to treatment. The law does not mandate that written informed consent be obtained. However, informed consent for sedation or general anesthesia is not valid unless it is in writing. Obtaining written informed consent is essential to providing proof of the required discussion process. So what does the informed consent aid in?
That's a good question because we do hear this frequently on the advice line. Using an informed consent will aid in guiding conversations, creating consistency, providing appropriate resources, and documenting the evidence. Informed consent is a fundamental component of managing risk in dentistry. It's a dialogue between a dentist and a patient about the nature of the recommended treatment, the risks, complications, and benefits of treatment, and alternatives. A signed informed consent form is considered the first line of defense when facing a professional liability claim. However, informed consent forms are not waivers. They neither relieve the dentists of their responsibilities nor protect dentists from the potential repercussions of providing treatment below the standard of care.
That's right. Dentists should give patients enough information to make a decision to either accept or refuse treatment. As I mentioned previously, when it comes to excessive questions or high-level apprehension on the patient's part, these are indicators of how much time and detail should be spent informing the patient of issues concerning the treatment. Carve out that additional time during the appointment to educate the patient on their treatment plan. To prove the discussion occurred, dentists are advised to establish a custom, that is, a habit in the way they practice. While a dentist may have trouble recalling the details of a specific case, they can convey the typical protocol that they would customarily employ for the procedure. While a sign and data form is important, the form is only one part of a broader process. More important, it is an open two-way conversation with patients to ensure they understand all the risks involved. Should a patient refuse to sign an informed consent form for whatever the reason, inquire as to why the patient is refusing. If after further explanation and the patient still refuses, this is a sign of non-compliance and a dismissal may be in order. There are times when you do not need to use the informed consent form. We also get this question many times in the risk management advice line. If your practice chooses an informed consent form for every single procedure, that's not to say that it's wrong. However, there are times when a practice wants to know when is it absolutely necessary to use a form. For simple and common procedures, such as remote risk, a form may not be required. One could argue that when a patient presents for an examination, they are giving implied consent by virtue of being there. An example is if a patient who's already sitting in the chair ready for the exam. For high-risk procedures and more invasive treatment, we highly recommend using a form. This slide has examples of invasive procedures that you should use a consent form for, and also non-invasive procedures that do not require an actual form. The non-invasive procedures have little to remote risk of failure or negative outcome.
Jessica, I'd like to share a couple of other questions that the dentists are asking frequently, which are, how often must we have an informed consent signed, and can trusted staff who are trained guide the discussion? TDIC recommends to have an informed consent signed each time you do an invasive procedure, documenting the date and tooth number at the top. For example, if you're working on 2 teeth for crowns on the same day at the same visit, simply write at the top tooth numbers 2 and 3. And while staff can assist with this process, it's not enough for staff to simply have the patient sign the informed consent. TDIC recommends that this is a discussion the dentist has a responsibility to have with the patient before the treatment is rendered, ensuring all their questions are answered. And as always, be sure to document that this discussion took place. Jessica will cover chart notations in just a few slides. Now that we've covered when to use informed consent forms, I'd like to show you where to access them. When you visit the TDIC website, the forms are located under the risk management heading and informed consent. We'd like to encourage you to explore the variety of risk management resources and reference guides that can help you identify potential risks and manage unfavorable situations should they arise. These include forms and samples for documenting key aspects of the doctor-patient relationship, as well as opportunities for seminars and self-studies, which keep dentists abreast of timely practice issues and address the latest news and industry trends. Based on a higher rate of claims activity identified for specific procedures, TDIC has chosen to develop 22 consent forms in 9 languages, which are English, Spanish, Chinese, traditional Chinese, Japanese, Korean, Russian, Tagalog, and Vietnamese. And our forms do go through a thorough review process. TDIC informed consents are reviewed by the risk management analysts, dentists, subject matter experts, and attorneys. Our attorneys that review the forms are the same attorneys that represent our dentists in malpractice claims, so they know what's essential to discuss with the patient prior to receiving treatment. As a side note, we occasionally consider requests for forms. This was the case with our informed consent form for fillings. The fillings informed consent does not have high claims activity. However, based on the demand from members, we decided to create one. Jessica, would you like to show an example of an informed consent form?
Yes, of course. Thank you, Jamie. Here's an example of an extraction informed consent you may find on the TDIC website. TDIC recommends having the patient initial each line item and sign the form. Some of the informed consents are more than one page. Although it may seem like that is too many pages or too long, listing all the risks involved and the invasive procedures allows the patient the opportunity to review the information and open a dialogue. Some questions we get is, can a patient sign the informed consent digitally? The answer is yes. Check with your software on how you can scan the informed consent digitally and the efficiency of printing a copy for the patient. Can the staff sign the informed consent on behalf of doctor? As we discussed previously, the answer is no. If you look at the second page, the form does not have a staff signature field, thus meaning the dentist signs the informed consent form. When you have a consent form and you had a discussion, is there anything else to consider? Yes, TDIC recommends incorporating a chart notation. Here is an example of a chart entry for an office that has consent forms. This notation is an example of what you might include in your chart. So this is in addition to using an informed consent form. One could say this is a poster child example. I had a call once regarding an informed consent. Patient was a long-standing patient and was scheduled an appointment because her tooth was broken due to a fall. The treatment plan was to extract and place an implant. After the tooth was extracted and implant was placed, the patient returned to the office upset that she wasn't given the option of a bridge because it turns out the cost of the implant was more than she could afford. The patient then proceeded to allege that she never consented to the treatment and felt the office pressured her to get the implant. No informed consent was signed, and when the dentist reviewed the chart, it also appears he didn't document the RBAs were discussed and that the patient wanted to move forward with the treatment. This is now a case of the patient's words against the dentist. And because the dentist did not have any documentation to back up his claim, it did not help in his case. And Jamie, do you have any cause related to informed consents you would like to share?
Yes, I do. In this call, the patient had presented for a crown prep on tooth number 29. After the patient was numb, the dentist started the procedure. The dentist noticed the radiograph and remembered that this tooth had a suspicious root canal. In the past, he had discussed this concern with the patient, but felt it might be a good day to retreat it since she was already numb. He took a quick look at the schedule and revealed that he had enough time. The dentist informed the patient of this, and since she was a longtime patient, she trusted the dentist and didn't feel it necessary to ask many questions. The dentist got started, and unfortunately, things did not go as planned, and he perforated the tooth. He immediately informed the patient and assured her that he would get her over to a specialist that would be able to see her the same day to evaluate the tooth. The patient agreed to go to the specialist, and the dentist reassured her that everything would be fine. The patient went to her appointment at the endodontist office, and that evening, the endodontist called the dentist and informed him that the tooth could not be saved and would need to be extracted. The endodontist had discussed this with the patient and informed her that this is a risk of the procedure. He suggested that she return to the dentist for extraction and that together they could figure out a treatment plan moving forward. The dentist contacted the patient that evening and left a message for her to return his call so they could set up an extraction appointment and to schedule time to discuss the treatment plan moving forward. The next morning, the patient did call the office. However, she did not ask to talk to the dentist, but did ask questions about the procedure that was done and the fees associated. The front office staff asked her if she could hold the line so that they could get the dentist to speak with her, but the patient refused and said she would call back. It was this situation that prompted the dentist to call our advice line.
Thank you for sharing that story, Jamie. And what were your recommendations?
We discussed the importance of the informed consent process for all invasive treatment, even if the relationship and rapport with the patient is long-term and positive. The dentist admitted that he didn't have a retreat for root canal informed consent because he doesn't do them often, and this was a huge red flag. If the dentist had a form or implemented the informed consent process by explaining the risks, benefits, and alternatives to the patient, it would have helped the situation. If this complaint would have gone to litigation, it would have been more defensible. Fortunately, the dentist and the patient were able to work out a solution. He agreed to refund what she paid and offered to pay for an implant. Now, some of you might consider that to be a bit much, but when you carefully examine the red flags and the risk of litigation, this was reasonable for the dentist. I provided the dentist with a release of liability form that the patient signed in exchange for the refund. And at the conclusion of this call, I reviewed the importance of the informed consent process. The dentist agreed to implement this process, and the ultimate result was a resolved matter, a maintained doctor-patient relationship, and no claim.
Great advice, Jamie. And good point that every situation is different. So when in doubt, you have the option to call the risk management advice line. Patients argued that they would have made a different treatment decision had they known of the possibility of a negative outcome. Patients must be informed about their treatment, and obtaining an informed consent is the best way to protect the patient and the doctor. Sometimes we often hear that it is too difficult to document everything. Going back to what's on this slide, take a look at the red underlined area of the chart. You don't have to use these same exact words, but keeping it consistent is a good practice in your office. Having a signed form in this notation is ideal, and this is what defense attorney likes to see. This next slide is about the components of informed consent process. I will pass this over to Jamie to discuss further.
Thank you, Jessica. First, to begin the informed consent discussion is the nature of the recommended treatment and why the procedure is being recommended. Second are the risks, benefits, and alternatives of the treatment, referred to as the RBAs, including no treatment. For better patient understanding, the informed consent form ought to be discussed in lay terms. Just as a patient should know the risks, benefits, and alternatives of accepting a treatment recommendation, he or she should know the potential consequences of refusing a proposed treatment or procedure. For example, a patient who refuses the recommendation to extract a completely bony impacted third molar must understand the potential for continued symptoms, bone loss, and serious, potentially life-threatening infection. Using a form provides opportunities to expand and enrich the discussion. Forms can work as a checklist and a reminder for the dentist to cover all of the information the patient needs to know to make an informed decision. They can also help the dentist and patient stay focused on the treatment issues, supplement what the patient could not comprehend or remember due to anxiety at the time of the discussion, reinforce what the patient heard and understood during the discussion, and serve as documentation of the facts that were discussed. While the form lists the risks, benefits, and alternatives, it may not be enough to cover the information a patient may later allege. This can be addressed by using phrases such as the following: not limited to the following. The information listed on this form covers only general information. And the dentist has personally discussed the material, and the patient was given an opportunity to ask questions prior to the treatment. All right, it looks like we have another poll question. Let's see if you noted this down. So TDIC has how many different informed consent forms and how many different languages? Looks like the answer is A, 22 informed consent forms in 9 languages.
That was a tricky poll question. Good job to those that got it right. Okay, next up is who can provide consent. I will go over minors, language barriers, and patients not of sound mind. I'll start with the concerns surrounding minors. Some of the questions the advice line has received are, can a family friend sign the consent? What about a sibling who is of adult age? And can grandma and grandpa sign the consent? These are all good questions, and the answer is no. Only the legal parent or guardian can consent to treatment unless there is a signed authorization on file. To obtain a signed authorization on file, TDIC does have a form for this, and the form can also be found on the TDIC website. The name of the form is Authorization for Agent to Consent to Dental Treatment of a Minor. The purpose of this form is if the parent or legal guardian is not present with the child to consent for treatment. The parent can sign this form authorizing an adult whose care of the minor has been entrusted. Next up is language barriers. Communication is essential and vital to build trust between you and the patient. Language barriers poses challenges in terms of communication. So how do you address these challenges? Well, you can have an interpreter option for the patient. An interpreter can be anyone that the patient entrusts, such as a relative, friend, or even a staff member. Be direct in letting the patient know that it is best to have an interpreter at every appointment. This will not only benefit you, but also the patient. This effort will ensure you're able to communicate effectively. The last thing you want is to be faced with a situation in which there was a loss in translation between you and the patient. When you find yourself in a situation where you're not confident in the discussion process, hire an interpreter or let the patient know that you don't believe you can communicate effectively without an interpreter present. Let's not forget about the TDIC informed consent offered in different languages. This is not to say you're replacing an interpreter. As mentioned before, the informed consent process is not just a form, but a discussion. Lastly, the advice line gets many calls about patients who are not of sound mind. Usually it is the elderly patients that draw concerns. For independent patients, determining who is responsible for treatment and financial decision is not an issue. But for those who may depend on a caregiver or family member, office staff should ask whether the patient has given the power of attorney to a specific individual. If not, dentists should always obtain consent from the patient prior to discussing any treatment with a third party, including the patient's family members. Older adults are valued patients at dental practices, and ensuring their safety and health requires particular care and precaution. Clear communication, thorough documentation, high observation, and specific protocols to help mitigate any potential liability risks while keeping older patients safe. If you feel the patient is not of sound mind, do not proceed with treatment. Next up, we will discuss protocols, and I'll hand this back over to Jamie.
Now we'd like to go over how to review your protocol to tie it all together. Some questions to ask to evaluate your protocol are, is your current process efficient? If not, what are some ways the process can be improved? What needs to change? Are all of your staff members following the process? Communicate with the staff to ensure everyone is on board. Identify and address breakdowns in the process and maintain smoother day-to-day operations. Prior to treatment, consider what this process looks like. Are you taking the time to go over the informed consents? How about using any visual cues? Visual cues are different for every office, and we recommend determining and implementing a system for visual cues that work best for you and your staff. Are you familiar with the timeout procedure? Federal law requires medical doctors and hospitals to follow a timeout procedure prior to performing a surgical procedure. And even though dentists are not required to do this, TDIC recommends adding timeouts as an important component of your protocol and encourage you to consider implementing it. So what would a timeout look like in the dental practice? Here are the steps of a timeout. Review the daily schedule during the morning huddle and cross-reference charts and treatment plans against the schedule at the time the patient is taken into the operatory. In addition to verifying treatment plans against the schedule, ensure the radiographs belong to the patient and match the treatment plan. If the patient is a minor, review the treatment plan and have an informed consent discussion with the parent or the guardian. Count the teeth to ensure you're treating the right tooth. After these steps, allow the patient and/or the patient's parent or guardian the opportunity to ask questions to understand what to expect at each appointment. A properly executed timeout procedure was found to drastically reduce mistakes and on average only added about 18 seconds onto the appointment. That's a small thing to do with a big payoff.
Yes, and how many of us have heard or even experienced that just taking those extra measures or steps can reduce our risk? Let's review the steps Jamie just went over in this short video clip. All right, well, I hope you found that video to be informative. We are now going to get right into refunds. So this poll question is related to a refund, and we are curious to see what you think. Giving a refund an admission of guilt? A, true, B, false. Give you just a few moments to answer. All right, let's see the results. Great, all of you got it right. The answer is false. It is a business decision and not an admission of guilt. Let's go over what your options are if you do happen to get that refund request. All right, so let's be honest. Who here can say they love giving money away? Well, for a good cause, yes, but in a business decision, it's not so fun, right? Before we go into discussing options, I'd like to share an example of a call. And while I'm telling this story, think about what you would do in this situation. A patient was in the office for a root canal treatment on tooth number 30. The dentist administered anesthesia, which included a block, and proceeded with treatment. The visit was uneventful. The office called patient the next day to see how the patient was doing. At that time, she reported that the numbness on her lip and chin had not gone away. The office consulted with the dentist, and he wanted to get the patient back in to evaluate the site. However, the patient refused to return to the office. The dentist called the patient himself and offered to refer her directly to an oral surgeon to assess the extent of the paresthesia. The patient asked for a refund instead, and if he could cover the crown that was needed, since this whole ordeal was more than she bargained for. The dentist agreed to the refund, but insisted that the patient still needed to see an oral surgeon. The patient said she would think about it. 2 days later, the patient called and reported continued numbness and stress from the fear that the numbness won't go away. She went to see a chiropractor to alleviate the tension in her back and neck from all the stress she had endured. She asked if the dentist would be willing to cover those expenses. He told the patient he was going to need to think about it. She then threatened to sue if he did not pay for everything that she has demanded up to this point. As an effort to avoid the threats, he agreed to comply with the patient's request. With this story in mind, Jamie, what would be our recommendations on what the dentist could have done?
This can happen. So don't get intimidated by the patient and feel that you must agree to everything they're demanding to avoid legal action. At times, we do get caught up in the moment, especially when a patient is threatening a lawsuit. The first thing in this situation is to ask, what is reasonable? In this case, the patient still was not seen by an oral surgeon to assess the area, yet the dentist agreed to the patient's request to the refund and the chiropractor expenses. When a patient's making a demand for a refund, we recommend that you assess and evaluate the merits of their request. Ask yourself, was the treatment substandard? And why is the patient upset? We also suggest that when you get a demand such as this, consider responding versus not doing anything, even if you plan on declining the request. After assessing the situation, what's next? Consider your options, which are you may comply with the patient's demand. You can compromise by giving a partial refund. You may choose to stand by your work and respectfully decline, or you can ignore the patient's request, which is typically not recommended. Patients who feel that they're being ignored are more likely to engage the services of an attorney. As mentioned, you could offer to compromise for a lesser amount or turn it over to your liability carrier for more assistance. Now, going back to the story, the recommendation is to assess the situation before complying to the patient's request.
Now it's time for empowerment. This is how you decide if you will provide a refund. Call your malpractice carrier if you need guidance. Here are some things to consider before refunding. Number one is, can you afford to give the refund? Is it a reasonable request? If not, why? And what is the disposition of the patient?
And how about what a colleague would say about your treatment? Consider their feedback. This is peer collaboration, and it'll help you identify your course of action. It's starkly different if your course of action is starkly different than that of a colleague. If it's a situation where you need to refer the patient for a second opinion, be sure who you are giving the referral to is someone you trust and have a solid working relationship with. This gives you the opportunity to engage on what your colleague's clinical findings are. If the patient feels that the treatment was substandard, then inquire. Do they have a new dentist, or did they get the opinion of a specialist? Was it a clinical diagnosis or just an opinion? If the patient did seek a second opinion outside of your referral, you have the right to ask for a report before you make an informed decision. If the patient does not want to provide the report or does not want to sign a release for the other dentist to provide the report, then take the time to review if you should consider the refund. For patients that refuse to give you information, consider the sincerity of their concern.
Here are some general guidelines to help you decide what to do. Review your records to confirm if there is a signed consent on file and that RBAs were discussed. The treatment plan should have the patient's signature. It should also show what treatment is being performed and what is the patient's out-of-pocket cost would be. Along with the treatment plan should be a financial agreement with the patient's signature as well. It should be well outlined so the patient understands any fees that's not covered by their dental insurance are their responsibility. And what about radiographs? Were pre-op x-rays taken showing the need for treatment? And does the post-op x-ray show treatment was completed and sound? Review your treatment records. Is the treatment you provided defensible? Can you gather a clear picture of the treatment provided? This is important because your chart records are your best defense. If you stand by your work and feel that the demand for the refund is unreasonable, you have the option to make the decision to decline the request.
Here, I'd like to take a moment to acknowledge the impact that the pandemic has had on dental practices. We understand that declining to provide a refund has been more difficult than ever for so many, especially with the added expense of PPE, office equipment, and loss in revenue, leading to significant financial strain. As one could guess, the TDIC advice line has received an astonishing number of calls related to COVID-19. In the year of 2020, the advice line handled 2,267 calls related to COVID. The high number of COVID calls are tracked by TDIC for the purpose of developing up-to-date resources for our members during this national crisis and beyond. Jess, would you like to go over additional refund considerations?
Yes, of course. Thank you, Jamie. During these times, it might be a financial burden to provide a refund. You may have incurred lab fees and chair time. If it is a substantial amount, determine if it is appropriate to withhold those fees from the refund. There may be times when your peace of mind is worth complying with the refund demand. Other times, you may choose to deny the request for the refund. It is important to confirm that this is an amicable decision and the amount is clear-cut prior to providing a check or refund back to the source, whether it be the patient's insurance or a credit card merchant. We don't recommend paying for pain and suffering in addition to the refund. If the patient asks for pain and suffering compensation, contact the advice line prior to complying. Many times, the patient will demand the insurance portion be refunded back to them, but the insurance portion needs to go back to the insurance and not the patient. Contact the insurance and ask what steps are for refunding their portion. If the patient paid with the health savings account, the money would need to go back to the card because the money on the card is pre-tax. Care credit also requires you to reverse the charges back to the patient's care credit account. And what about the reasons as to why patients may be asking for a refund?
I can go over some of the reasons, Jess. When a patient does request a refund, there are many reasons why. Understanding the reasons why a patient is making a refund request may aid in your decision. Some reasons are miscommunication happens on both ends, poor results, which is treatment that failed, a dissatisfied patient, the patient's not pleased with the outcome, incomplete treatment, a crown that never gets permanently seated, or a denture that never gets picked up. A business decision. Declining may lead to additional loss of time and money.
And I'm glad you brought up those reasons, Jamie. An example of a miscommunication is a patient of record was treated for a crown. A PFM was prepped and cemented. The treatment went well, but the patient was not pleased with the aesthetics of the crown. She did not like the dark line along the margins of the crown. The dentist explained to the patient this dark line is common for this kind of restoration, but if she had paid a little extra for a different kind of material, the line would not be there. The patient became upset with this, that she was not given this option. Upon the review of the records, there was no documented conversation that this option was given to the patient. The dentist offered to redo the crown at no cost, but the patient had lost confidence in the office and ultimately wanted a different dentist to redo the crown. She asked for a refund. The dentist did not want to provide this refund because he felt that it was an admission of guilt and there was nothing clinically wrong with the crown. Based on this example, what would you do? Would you refund out of goodwill and compromise because of the miscommunication? Or would you decline the request because the treatment was sound? There really is no wrong or right answer here, but the biggest lesson is to be sure you are assessing the situation before complying to the patient's demand. Now, for those of you that would agree to the refund, there are recommendations on how to handle refunding patients, along with the release of liability form. Some of you may be asking, well, how important is it to have a release of liability form in exchange for a refund?
If you have asked that question, or even if you haven't thought about it yet, we'll go ahead and go over that right now. When you have determined a refund is appropriate, there is documentation that can help facilitate the process. We have a release of liability and a forgiving balance form. Let's discuss the release of liability first. When a refund is a mutually acceptable solution, having the patient sign a document shows that the patient intends on accepting the refund as a final resolution. The release of liability also states that you are refunding out of a goodwill gesture and in the interest of compromise. This allows the patient to acknowledge that you're not admitting guilt. Keep a copy as evidence of this agreement. Having documentation is your best and first line of defense in the event of a complaint. A signed release should not be kept in the patient's chart as it is not treatment related. We suggest the document be kept in a separate file titled "In Anticipation of Litigation" to provide as part of your defense in the event a patient files a complaint or pursues legal action. Now, while having a release can help the case if one should be brought forth, it will not grant you complete immunity, nor does it relieve you of the responsibility to practice within the standard of care.
So on this slide is an example of the forgiving balance form from TDIC. There are times when a patient withholds further payment for treatment until the treatment satisfaction is reached. When a dissatisfied patient complains and refuses to pay the balance due, the doctor can offer to write off the balance in exchange for a signed forgiving balance form. When using this form, describe the exact treatment in question to eliminate any confusion about what you are forgiving. You can document whether you're forgiving a portion or all of the balance.
Good point, Jessica. Prior to offering to forgive the patient's balance, it's important to determine if all efforts have been exhausted before taking this step. as you don't want a reputation of writing off balances the moment the patient complains. I'd like to share a story as an example of a forgiving balance scenario. Risk management received a call to the advice line regarding a patient who opted for implants and implant-supported dentures. The dentist didn't encounter any difficulties through the course of the treatment and was pleased with the case results. However, the patient continued to complain and returned to the office, criticizing the final outcome. It was evident the dentist and the patient couldn't find an amicable solution, and he was not able to meet the patient's expectations. The expectations were unrealistic, and the patient's husband was involved with the treatment process. He also expressed his dissatisfaction. The patient and her husband called the office daily, and the husband became hostile towards staff and the dentist. The husband made comments such as, "She should look younger with her new teeth," and "the teeth just aren't shaped right," and "her speech is slurred." The dentist tried to explain it takes time to adjust. The dentist had exhausted all efforts to gain satisfaction, and after numerous attempts, he started to lose tolerance for dealing with this. The patient had a balance due for the treatment, and he suspected that the balance might be contributing to the dispute. The dentist was not in the habit of forgiving balances, but with this scenario, he was willing to find a resolution, so he offered to forgive the balance owed. In this case, once the patient didn't have the balance hanging over her head, she became more reasonable about the expectations and was willing to accept the fact that she needed time to adjust. Now let's check in with a poll question. When considering a refund, you should return the insurance portion back to the patient, true or false? The answer is B, false. Insurance money should be returned to the source. You can reach out to the insurance company on what the steps are for refunding their portion. Next, we'll discuss orthodontic refunds. The TDIC Risk Management Advice Line has received numerous calls regarding patients who are in active orthodontic treatment and, for various reasons, requesting a refund. Here are some examples. The patients moved out of the area or go away to college before treatment is completed, and they need to deband early. A patient falls behind on their payments, so they fail appointments or cancel. A patient is complaining about lack of progress and now refusing to pay. The patient's not satisfied with the length of time the treatment is needed to reach the satisfactory progress. The patient has lost their income and are unable to continue paying for the treatment. The doctor-patient relationship is failing or unable to be established. And the patient has been non-compliant with appointments, maintaining oral hygiene, or following through with the necessary treatment recommendations. Jessica, anything else to add to non-compliance?
Yes, Jamie, thank you. I would like to add that when the reason is non-compliance, the dentist may need to send a warning letter with a deadline to comply, or a non-compliance dismissal might be necessary. This should be the final course of action, and we don't recommend taking it lightly. As for ortho, the TDIC website does have ortho sample forms. We have the following sample forms: lack of progress report, statement of satisfaction and retainer, and early removal of braces or debanding. Risk management does have recommendations on how to manage the situation for early deband. Call the risk management advice line to discuss your options.
I'd also like to add that regardless of the reason, taking proper steps in handling the matter is crucial. Make sure to have comprehensive documentation and justification for the decision. If the patient tells you that they are going to continue treatment elsewhere and they don't want their braces or appliance removed, please contact risk management. We typically recommend removing appliances and providing a retainer at no charge so any movement can be maintained. Now, of course, this is your decision, and you must make the clinical determination for what's best for the patient. There is liability when the patient remains in the appliances you placed and you can't ensure the patient is being monitored. We will be discussing additional mid-treatment cases in an upcoming slide.
When risk management gets a call from a dentist asking about what steps to take when refunding a patient, we ask, how did the patient pay for the treatment? Did someone help with the balance? Sometimes the patient's family member, husband, or friend is asking for the refund on behalf of the patient. It needs to be determined if the third party paid for the treatment and if patient has even agreed to the refund. If the spouse is demanding for the refund, it shouldn't be assumed that they're entitled to the refund just because they may share the account. If it is determined the family member paid for the treatment and you need to discuss treatment, it is good practice to have a signed authorization to disclose personal health information. This document is necessary as there are privacy laws that protect the patient's personal health information. The form to disclose personal health information is signed by the patient or the minor's parent or legal guardian or the patient's personal representative. A personal representative includes a guardian or conservator of the patient. It can also be signed by a beneficiary or representative of a deceased patient. If the patient filed for a grievance with their dental insurance and the insurance company, after they do their review, is requesting a refund from you, then the insurance portion would go back to the insurance company. If the patient is deceased and was in mid-treatment, the executor of an estate or an authorized representative would need to provide documentation that they have the authority on behalf of the former patient to make the request for a refund.
This brings up a call I would like to share. This patient passed away while in temporary crowns, and the patient had prepaid for the treatment. The patient's daughter called the office demanding that the money be sent to her. The office manager thought it was appropriate to refund her since she had brought her mom to her appointments and seemed to be involved with the treatment decisions. A few months later, the patient's son calls to inquire about the refund as he is the authorized person to receive the money and had documentation to prove it. The patient's daughter was not willing to give her brother the money that she received, and this put the dentist in the middle of a dilemma that could have been avoided.
Thank you for sharing that story, Jamie. That was a good story to share.
You're welcome.
Okay, so picking up where we left off on refunds, here are a list of some do's when considering a refund. Do call your professional liability carrier when you are unsure how to proceed. Do investigate before you take the position of it's a matter of principle. Do return money back to the source. This practice eliminates confusion and keeps accurate record of the transaction. And do contact your professional liability carrier if the patient is asking for more than just a refund. And what about the don'ts, Jamie?
Don't ignore a request for a refund. This can aggravate the situation. Don't inflame the situation. Remain calm and professional as it is a business decision. Don't give in to patients who demand for you to give the insurance portion back to them. You may be violating your contractual obligation to the dental insurance carrier. Don't get caught without using an informed consent for invasive procedures. There are many different scenarios regarding refunds. If you're faced with a refund request you're not sure how to respond to, feel free to call the risk management advice line and we'd love to assist you. Now we'd like to go over the important topic of patient dismissals. It can be draining and stressful to deal with an unhappy or non-compliant patient, and you may feel forced to make some tough decisions. You'll need to determine what your tolerance level is for dealing with the matter and take a moment to stop and gather your thoughts. After the decision to refund is made, you will then need to decide if you want to continue care. Jess, would you like to review some points to consider before dismissing a patient?
Sure, Jamie, thank you. Sometimes after refunding a patient, you may be thinking, should I dismiss? Some questions to ask yourself are, is this a long-standing patient? Was other treatment completed without incident and this treatment just didn't go as planned? Is the patient a good fit for your practice? How does the patient treat your staff? Do you and the patient trust each other? And is the patient in mid-treatment? Some examples of when it is appropriate to dismiss are when patients are hostile or threatening, when the patient is dictating treatment or neglecting to follow up with care, When the patient is disrespectful to staff or harassing staff, such as calling multiple times, using derogatory language or inappropriate advances. And also watch out for the red flags, such as when the patient complains about previous dentists or brags about previous lawsuits. This is not an exhaustive list, and calls to the Vice line can initiate other reasons for dismissal. Dismissing a patient is never easy, and more importantly, it can include significant risk. If you're not careful in handling these situations, it could result in allegations of patient abandonment.
Here we'd like to point out how to check for warning signs in a patient behavior or demeanor and be aware of red flags. We recommend paying attention to the signs, and if you have a gut feeling about a patient, listen to it. So what are some warning signs? The patient refuses to take radiographs and offers to sign an informed refusal. Allowing the patient to refuse necessary recommendations puts the dentist at risk for supervised neglect. Just as patients should know the risks, benefits, and alternatives of accepting treatment recommendation, they should also know the potential consequences of refusing a proposed treatment or procedure. If the patient's refusal of treatment jeopardizes the patient's health, dismissing the patient may need to be considered. Remember, obtaining an informed consent does not relieve the dentist of the responsibility and potential consequences of practicing below the standard of care. Often patients will refuse scaling and root planing when diagnosed with periodontal disease. They demand that they get their covered cleaning by insurance, and they'll argue, I get 2 cleanings per year per my insurance. It's up to the dentist to educate the patient and determine if the patient's refusal will be harmful to their dental health. Patients can have unrealistic expectations. A discussion about expectations should be a high priority and thoroughly documented. One example of a call received on the risk management advice line was when a patient came to an appointment with an expectation of getting dentures, and she wanted them before her daughter's wedding, which was less than a month away. She still needed extractions of some remaining teeth, and it would take multiple appointments for try-in, bite registration, and a need for additional healing time. The dentist wasn't sure if he could meet the patient's expectations, considering there's an adjustment period for dentures and the patient could experience sore spots and develop ulcers. The risk management analyst advised the dentist to keep in mind the patients have very little knowledge when it comes to dentistry, so clear communication is key. If the patient still has unrealistic expectations, it may be best to not take the case. Another warning sign is hostility towards the staff. So what's considered being hostile towards staff? If a patient is raising their voice, derogatory or abusive communication, belittling, such as telling the staff they don't know what they're doing, negative reviews, slandering the office, slamming things on the counter, calling the office repeatedly, and making threats to complain to the dental board or complain to their insurance or taking the dentist to court. How do you manage this? Well, set clear expectations for professionalism, communication, and interpersonal interaction among staff members and between staff and patients. When communication breakdowns happen, the environment can quickly become toxic. However, it's the role of the practice owner to facilitate a safe environment so staff members feel comfortable voicing their concerns. Every patient will require a different level of care and attention, but it's never acceptable for the patient to be abusive to any member of the dental team. Taking action in a prompt manner is important, as it prevents the issue from potentially escalating or becoming a chronic problem. This type of behavior is inappropriate, and depending on the situation, it would be an immediate dismissal or a serious conversation with the patient. Jessica, do you have anything to add about hostility towards staff?
Yes, I do. Thank you, Jamie. The risk management advice line has received numerous calls as of recently about patients who are physically aggressive towards staff, such as throwing their purse at an assistant, slapping a hygienist's hands while in the middle of treatment, threatening the dentist's life, and inappropriate advances towards the front staff. In situations like these, as Jamie mentioned, it needs to be addressed immediately with a dismissal. If the patient is violent and refuses to leave your office, do not hesitate to call the authorities. It is also important to get a copy of the police report for your records. All right, it looks like we have another poll to tie into the warning signs we just went over. What is the best approach if staff is advising you that a patient is hostile? Is it A, reassure the employee you will address their concern, B, have a discussion with the patient, or C, A and B? And while you're logging in your answers, I want to add that in response to the uptick of patients being hostile, the risk management team has developed an article on how to manage this. When you get an opportunity, check out the RM Matters articles on the TDIC website. All right, so let's see what the results are. The answer is C, A and B. Great. It looks like all of you did get this right.
Occasionally, circumstances make it impossible to continue the dentist-patient relationship, and either party can end the relationship at any time. The dentist can withdraw from the patient's care as long as the reason is not unlawful or discriminatory. Withdrawing from care is never easy and should be handled with a formal notification in writing. Along with withdrawing from care, providing 30 days of emergency care is recommended, but not required in certain circumstances. The risk management analysts on the advice line can help you determine whether the emergency care would be required. So, who gets a dismissal letter? If you're dismissing a patient of record or an established patient, TDIC recommends sending a dismissal letter when ending the relationship. Patients may perceive the relationship is established when the doctor conducts the initial exam. A basis for the relationship exists even when no treatment is performed, such as if you provided the patient a consultation or a second opinion. If a relationship is established, dentists have the absolute right to withdraw from care. However, appropriate steps must be taken and documented to avoid liability and keep patients free from harm. If you're forced to dismiss a patient who brings their entire family to the practice, you can dismiss the entire family as long as you are not discriminating against any disabilities or if the patients are in mid-treatment. It is appropriate to send individual letters addressed to each patient. Analyze each situation on a case-by-case basis. If you need assistance with determining whether you need to send the letter, we encourage you to call the advice line.
TDIC recommends using the following 3 types of dismissal letters: no reason, non-compliance, or patient terminates.
Let's start with the no reason dismissal.
All right, Jamie, go ahead and take that away.
First, I'd like to share a case example of a no reason dismissal. A patient of record arrived 30 minutes late for a hygiene appointment. She started yelling at the staff after being told she was too late for her cleaning appointment and could not be seen that day. She threatened to sue the dentist if she was not seen that day. The staff remained calm and told her she would need to reschedule the appointment and would not be seen. After yelling a few choice words, she left the office. The next day, the patient sent an email saying she expected another appointment since they had refused to see her. The dentist called the patient to explain how being late impacted the schedule and why there was not enough time to perform the cleaning. He also told her that she cannot be rude and disrespectful to his staff. She became agitated during the conversation and hung up. The dentist documented the conversation in the patient's chart. This patient had no outstanding dental concerns or issues and was not in the middle of treatment. Based on the patient's behavior and comments, he dismissed the patient. Based on what we presented so far about dismissals, what do you think? Is it a requirement to give a reason when dismissing a patient from the practice? True or false? And let's see the results. Yep, the answer is false. There is no reason required. So a no reason dismissal is just that. You do not have to have a reason to dismiss the patient as long as you're not dismissing in mid-treatment or, as we mentioned before, discriminating against any disability, ethnicity, religion, or gender. The doctor has a right to choose who they're comfortable treating, and not every patient will be a good fit for the practice. Some reasons you may choose to dismiss using the no reason letter are if a patient has unrealistic expectations. For example, he or she brings in a photo of a celebrity or a photo from when they were younger and wants to look like the photo. Another reason is if the patient has a hostile or aggressive personality and makes demands that you're not comfortable with. We do not recommend allowing the patient to dictate the treatment. If you do not do what the patient wants, they can become confrontational and unreasonable. We recommend to pay attention to the red flags and trust your gut. Often staff members are at the brunt of the patient's hostility, so you do have a responsibility to protect them. Maybe the patient isn't aggressive or hostile, but you get that feeling that something just isn't right. Maybe they complain about their previous dentist, or they present to you with temporary crowns. It's important to take a time out and ask why the patient didn't complete their treatment. There are times that the patient will have a family member involved with their treatment decisions, and despite the patient being a good fit, the family member is not, and making it difficult to build a good relationship with the patient. Jessica will now review the noncompliance dismissal letter.
Thank you, Jamie. Some of you may already know this. Multiple failed appointments do tend to turn into noncompliance. The case example outlines when it is appropriate to send the failed appointment letter before sending the noncompliance dismissal. A general dentist called about a 40-year-old patient of record. The dentist said he was one of those patients who comes in only for emergency care and always tried to dictate his treatment. In 2018, the dentist diagnosed a deep decay and recommended a 3-surface filling on tooth number 3. The patient disappeared until 2020, when he called in extreme pain needing to be seen. The dentist was able to see him for same-day appointment and told him a crown was needed. They discussed the risks, benefits, and alternatives, and the dentist was willing to do the crown prep same day. However, the patient wanted to reschedule and just wanted the dentist to prescribe him pain meds. The patient was scheduled the following week, but failed the appointment again. The dentist called and was able to reschedule the next following week, and he failed that appointment as well. The office left 3 subsequent voicemails to try to get him in, but he did not respond. In this situation, what should you do next? Well, our recommendation is to send the failed appointment letter first. The letter should include the date of the missed appointment, your attempts to contact the patient, and the consequences of not following the treatment plan, and also a request to reschedule the appointment. Also, include a date by which the patient should contact your office. Consider sending the letter certified mail. Place a copy of the letter in the patient's chart. Should the deadline pass and your office has not heard from the patient, you can choose to send a second letter. This letter can be short, asking the patient to contact the office for an appointment by a certain date. Hopefully, you will hear from the patient and resume treatment. If you do not, now is the time to withdraw from the patient's care for noncompliance. Non-compliant patients are the ones who fail to follow treatment recommendations, and they continuously fail appointments, refuse care, dictate treatment, refuse radiographs, and refuse to see the specialist you have referred them to. Patients have the right not to follow instructions or the treatment plan. However, doing so is not within their best dental interests or could compromise their oral health. Explain the consequences, and if possible, help them decide to change their decision. When a patient still refuses to comply with the previously agreed upon dental plan, it is time to decide whether to continue seeing the patient or to dismiss. If you decide to allow the patient to stay in your practice and act in a non-compliant manner, you may be at risk for future allegations of supervised neglect. With non-compliant patients come a level of patient education prior to the dismissal. Patient education starts with a conversation discussing why the refusal could put the opportunity to educate the patient that radiographs diagnose more than areas of decay. Radiographs are useful tools in determining the presence and degree of decay, periodontal disease, and abscess or even abnormal growth such as tumors or cysts. They can also show the location of impacted or uninterrupted teeth. Without the use of radiographs, dentists diagnose and base their treatment planning on visual exams and may potentially miss critical issues not apparent to the naked eye. When you have a patient that regularly refuses radiographs, send them the diagnostic x-rays are required letter, which emphasizes the importance of diagnostic radiographs. Should the patient continue to refuse the radiographs, consider dismissing him or her from your practice. You can obtain the diagnostic x-rays are required letter on the TDIC website. Okay, so we talked about no reason and non-compliance dismissal. Now let's get into patient terminates care, and I'll hand this over to Jamie to discuss further.
Thank you, Jessica. I'd like to share an example of a patient terminating care, which I just want to say is my favorite type of dismissal, I have to admit. This patient had an appointment to have a bridge prep, and from the moment she walked in, she was upset over one thing or another. Her first complaint was that she'd tried to contact the office to inquire about her appointment and got the messaging service. She said that she never received a return call. After the patient was checked in, she had asked to be seated and waited to be called back. The dentist was running a little behind, so the assistant informed her that they would call her back shortly. She was not happy about this. Less than 10 minutes later, the assistant called her back and the patient rolled her eyes at the assistant when she asked how her day was. Her attitude was less than friendly. The first thing she said when she sat in the chair was, "My time is valuable." Already the appointment wasn't going well and they were barely getting started. The RDA removed the temporary bridge and let the dentist know the permanent bridge was ready for try-in. As you can imagine, the dentist got an earful when entering the operatory. Unfortunately, the permanent bridge was not seating properly, and the dentist informed the patient that he needed to take the impression and send it back to the lab. After talking to the patient and calming her down, the dentist thought that everything was fine, and she seemed to be understanding of the situation. Well, this was not the case. The receptionist told the dentist later that day that when the patient left, she said there was no way she would be returning to the office. The following day, the patient called asking to send her records to her new dentist. The office manager called to inquire about the reason for the request. The patient simply said, "I've lost confidence and I just want you to send my records." Whenever the office receives a request for records, it should be documented in the patient's chart, and the dentist should always be informed. The office complied and followed up with a formal patient terminates dismissal letter. In this case, documentation is crucial because the patient is in mid-treatment. It is the patient's right to choose a new dentist, but again, this choice and the circumstances need to be well documented. Patients decide to change dentists for a variety of reasons. Maybe they're moving out of the area or you're no longer a provider for their insurance. Other reasons could include that they're just not comfortable, or a good dentist and patient relationship cannot be established, or maybe it just isn't a good fit. If the request to transfer dental care comes as a surprise, the dentist or office manager might consider phoning the patient to discuss the reasons. A misunderstanding or minor challenge might be resolved with a simple phone call. Sending a patient terminates dismissal letter is a way to confirm the patient's decision to go elsewhere and that you acknowledge their decision. The letter states that you're willing to assist in any way to ensure a smooth transition. Be sure to document the exact date the patient advised you that they would not be returning to your office. And with this type of dismissal, you are not obligated to provide the 30 days of emergency care. Occasionally, we receive calls from dentists attempting to download the dismissal letter templates that are online. However, they're not accessible online like many of our other forms because we recommend that you speak to an analyst before making the final decision to send the dismissal. We hope to help you avoid claims of patient abandonment. Risk management can provide you with the dismissal letter templates. The options below need to be indicated on the dismissal letter depending on your circumstances. Option A states that you have reviewed the clinical circumstances and determined that their dental health will not be jeopardized by such a change. However, you urge the patient to place themselves under the care of another dentist without delay so that you can continue a sound program of dental care. Option B states that if the patient doesn't continue dental care with another dentist, immediately the following could result. You would fill in any risks or consequences, and you will be willing to consult with their new dentist regarding their case history, diagnosis, and treatment to allow for an easy transition. With the no reason and non-compliance dismissal, you also need to determine if you're providing 30, 60, or 90 days of emergency care. We recommend 30 days as that is ample time for the patient to find a new dentist.
Dentists must provide patients with written notice of intent to withdraw from dental care. No matter what the reasons might be for discharging a patient, the process should be handled cordially and after the dentist has tried to resolve any disputes. TDIC recommends when sending a dismissal letter, send the letter via certified mail with return receipt requested and also by regular first-class mail. We recommend being available for 30 days emergency care if there is a reason to believe that the staff or dentist safety is jeopardized. You are not required to provide the emergency care, but all incidents do need to be thoroughly documented.
We also recommend providing two options for finding a new provider. One, they can contact the local dental society, and two, contact their insurance for an in-network provider. Circumstances for each patient will vary considering treatment status, access to care, and availability of other dentists in the area. The certified letter should clearly alert the patient who requires specific dental attention, such as continued monitoring of periodontal disease. Enclose an authorization to release dental records form with instructions for the patient to sign it and return to the dental office. Notify your staff of the change in the patient's status to ensure the patient doesn't receive any further phone calls, reminders, or emails.
Jamie, good point on changing the patient's status to inactive so that they're not getting any emails or reminders. If this is missed, your front desk is not going to know that the patient is inactive and may schedule an appointment if the patient calls later. We get calls about accidentally scheduling a patient that has already been dismissed. And how awkward is that conversation, right?
Exactly. Hopefully none of you have had to experience that situation.
So what is considered mid-treatment? Is it when there is any portion of the treatment in progress that could put the patient at risk if you withdraw from care? Yes, of course. For example, an unfinished RCT that you started, temporary fillings, provisional restorations, and orthodontic cases are all considered mid-treatment. We recommend that you complete any dental treatment in progress when possible to protect yourself from allegations of abandonment and to protect the patient from injury. This does not mean you have to finish pending treatment. For example, any treatment that is listed in the treatment plan but has not started. As previously mentioned, in extreme situations, such as the patient is threatening or hostile towards you or your staff, and it may not be safe to complete the treatment, you can offer to refer the patient to a clinic or the local dental school. Now, some things to consider before withdrawing from care. Have you taken the time to sit down with the patient and discuss the concerns? Have you explained the need to complete the treatment and what risks are involved if the patient doesn't complete the treatment either with you or another dentist? Have you sent a formal letter to the patient? This is evidence that you are exhausting all your efforts. And have you objectively documented your efforts and the conversations? Next up, we will discuss the patient's access to records. Jamie, do you want to go over this piece?
Sure, Jessica. When dismissing a patient, as mentioned, we recommend providing a release of records form with the dismissal letter. The patient will more than likely request x-rays to be sent, and this request should be documented in the treatment notes as well as a signed release. The document will help you remain HIPAA compliant when sharing personal health information referred to as PHI. We have templates available, both the release of records and the release form to use or disclose PHI. The release form to disclose PHI is to be used when the patient wants you to discuss their personal information with a family member, spouse, friend, or caretaker. If the patient is requesting a copy of their records, you would use the release of records form. It's important to know the difference, as the consent to disclose has core elements that must be included, such as description of information to be shared, the name of the person or entity authorized, the name of the cover entity who may take the request, a description of the purpose, an expiration date, and the signature and date of the person or person's representative. I want to mention that the advice line does receive calls about patients who are upset because the receptionist or front desk staff has released personal health information to their spouse or a parent in the case of an adult child.
That's right, Jamie. And you should never assume that the patient wants their personal information shared just because it is a family member. For example, a patient who just turned 18 was asked to update health history, and patient disclosed that she is pregnant. The patient's mother is also a patient of record and had an appointment the following week. At checkout, the receptionist congratulated the patient's mom for becoming a grandma, only to find out that the patient's mom had no clue that her daughter was pregnant. The patient was not happy that her privacy was violated in this manner. HNS code 123.100 states that any patient or personal representative is entitled to expect or obtain a copy of their records. The healthcare provider has 15 days to comply with this request. The use or disclosure of personal health information is dictated by both federal HIPAA law and California law. State law is more restrictive than federal law, and it applies to all healthcare providers. State law allows the use or disclosure of personal health information with certain limitations and without patient authorization only to the following: other shared healthcare providers for treatment of the patient, certain entities for review and liability, arbitration, peer review, quality assurance, and quality assessment, county coroners and public health departments for official purposes, court order, law enforcement with search warrants, or other government entities with orders pursuant to their respective legal authority, and others required by law.
Since we're on the subject about records, the record retention guidelines are as follows. TDIC recommends 10 years from the date an adult patient was last seen, and 10 years from a minor patient's last treatment, or 7 years past the patient's 18th birthday, which would be age 25, whichever is longer. Do keep a log of the records that you shred, and patients who have not returned for treatment within 24 to 36 months are considered to be inactive. Now, to wrap up, I really hope you enjoyed this presentation and found the content to be helpful and informative. I will now hand this over to Risk Management Senior Analyst Taiba Suleiman for questions.
Thank you, Jessica and Jamie, for such a wonderful presentation. You guys did a great job, especially considering the time so late in the evening, at least for some of us like myself. My name is Taiba Suleiman, and I will be asking live questions to the presenters at this point. And looks like we don't have any questions in the Q&A box. So what I like to do at this point is to take this opportunity to go over some of the questions that come into our advice line within the allotted time. So with that, I'd like to go ahead and get started with Jamie. Jamie, if I want to dismiss a patient and the entire family is also patient in practice, should I dismiss the family? If so, do I send one dismissal letter, or should I send an individual dismissal letter to each patient? I know we talked about this question, but I just want to make sure that we reiterate on that, because this is a question, like I said, that does come up a lot in the advice line.
Mhm. Yes, so it would be at the dentist's discretion to dismiss the whole family. However, to avoid any awkwardness in the future, we do typically recommend dismissing the whole family as long as they are not mid-treatment. And you would send one dismissal letter per family member, so they each do get their own.
Perfect. Great answer. Thank you.
Welcome.
Jess, I'm going to go to you now. What is the process after a patient has already signed an informed refusal? Do we keep that patient within the practice, or should they be, for how long? And if not, what should we do?
So a patient's refusal should be thoroughly documented in the chart, just as we mentioned during the presentation, along with the dentist's attempts to inform the patient of the consequences of refusal. Basically, the reason is because you don't want to put yourself in a situation of supervised neglect. Supervised neglect may also result when the informed refusal is allowed to go on too long. You want to review charts periodically and pay attention to and act on recurring patient symptoms and complaints. If the patient continues to refuse the referral, then you want to withdraw from care. So as far as the length, it really depends on the situation. If it's just an x-ray or if it's a treatment recommendation, like a crown needs to be done or a root canal. Typically, we don't recommend that you allow the patient to refuse treatment for a long time. If the patient continues to refuse treatment more than twice, I would recommend that you call the advice line to discuss further options.
Yes, thank you. So basically, it all depends on the scenario, and
Exactly.
we don't have a chart where we would say it's okay to keep this patient for 6 months or a year. It just all depends on what the situation is and the patient's symptoms and what the reason is for noncompliance and refusing the treatment.
Mhm.
So we're going to shift gears a little bit here and talk about release of liability. Jamie, I'm going to go to you. What if a patient doesn't want to sign a release of liability? I mean, they want a refund, but yet they're refusing to sign. Do I still refund the patient or not refund?
So the decision to refund, it is still a business decision. However, if the patient refuses to sign the release of liability and they accept the refund, then by default, they are agreeing to the terms.
Okay, thank you. While on that subject, Jessica, let me ask you a question about if a patient doesn't pay their outstanding balance, and yet they're in a provisional. Should we deliver the permanent crown, or can we withhold the treatment until the patient is caught up with their balance?
That is a good question. We get this question a lot. If the patient doesn't pay for the balance, we don't recommend that you withhold treatment for payment. You want to exhaust, all your opportunities to cement the crown and then proceed with your collections protocols. Simply because you don't want to put the patient in a situation where the oral health could be at risk. Sometimes we get the question if the patient wants you to hand over the crown to them. So we do get those questions sometimes. And with that, we also recommend that you do not hand over the crown, since you will not be the dentist overseeing their treatment.
Perfect. And Jamie, I will switch it back over to you. If for the informed consent forms, do we have to use the TDIC forms? What are your recommendations?
That's a good question. I do get this question quite a bit on the advice line. So some offices have developed their own, and that's okay. We do provide the resource there. It's certainly at the doctor's discretion whether or not to use that. As mentioned, our forms do go through a thorough review process. They're thorough, and the attorneys that review them, they know that they do cover what's needed in the event there is a complaint. But that being said, even in lieu of not having a form, as long as the informed consent discussion takes place and there is documentation in the chart that the RBAs were covered, patient's questions were answered. It's more thorough to have a form, but that chart note would suffice.
Thank you. Jess, we're going to go back to you. And this question has to do with request for records. In this particular scenario, it's a request from an attorney representing the patient. How should we proceed when we do receive those requests from a patient who has now retained the services of an attorney?
So when you do get the records request from an attorney, you want to be sure that there is a signed authorization from the patient in order for you to release the records. If you're noticing that the records request from the attorney does not have a signed authorization attached, you do not want to release the records. Just because it's coming from an attorney doesn't mean that you simply just hand over the copies without a signed authorization. Now, unless it's gone through the courts and you've received a subpoena for records request, then you don't need to look for that sign off. You can go ahead and just release the copy of records.
Perfect, thank you. And a follow-up question to that actually that comes up. If the patient is owing a balance, they have an outstanding balance, must I comply with the request for records?
So even if the patient has an outstanding balance, then yes, you still want to comply to the records request. A patient with an outstanding balance is a difference. There are two different types of situations. So the answer is, even with outstanding balance, you still want to provide the records request.
Okay. And sometimes our office charges for duplicating x-rays, for example, if it's a huge chart. What if the patient refuses to pay before we release the records?
So you can charge for the records, even if the patient refuses to pay for the records, they're ultimately have the right to request for the records. So you can try to ask for a fee first. And if you get pushback, then our recommendation is just to go ahead and provide the copies of records. You don't want to be put in a situation where they put in a complaint against you that you're not giving them the right to their records.
Okay, thank you. Jamie, let's go back to you now. On the topic of records, are models considered as part of a patient record?
Yes, they are. So if a patient requests their complete record, that would include everything. Models are included in that. So you would be obligated to provide a copy of the models.
Okay, thank you. And then let's see. Oh, this one is a good one, actually. It does come up, and you guys did touch up on it. If a patient has been dismissed from the practice, but keeps calling and wanting to come back, and hopefully the receptionist did remember to mark this patient as a patient that was dismissed, other than doesn't get scheduled. What do we do if they continue to call and harass the office?
I can go ahead and take that question. So once you dismiss a patient, you do not want to invite them back into the office. Think of it this way: you dismiss them for a reason to begin with. And we do get these calls all the time where the patient gets dismissed and they go to another office and they're not happy with the care with the other office. Then they want to then return back to your office. Think of it as, why did you dismiss this patient in the first place? And if trust was already broken to begin with when you first dismissed a patient, taking the patient back in, I don't think that there's a high chance that you can rebuild that trust. And it's not the patient's trust of you, it's if you trust the patient and if you're even comfortable to treat the patient again. So we recommend, if once they're dismissed, don't invite them back into the practice.
Okay. Thank you. I think we have time to squeeze one more question in there. And Jamie, this is going to be for you. If a patient's spouse accompanies the patient to every appointment and calls later asking about that patient's treatment information, can we disclose the information with the spouse?
This is a frequent question, yes. So as long as the patient has provided signed authorization to disclose the personal health information with that person. And it can be a little confusing, especially if they're coming to the appointments with the patient. Maybe they're even paying for the appointments. And, the thought is that they can just discuss the treatment with that spouse or, family member or friend or caregiver. However, if you do not have signed authorization, it is a violation of that privacy. So make sure you do have the signed authorization before discussing any treatment information.
Thank you. Thank you both. I think that's it for the questions. So if you have any further questions or would like to discuss anything further in regards to this presentation or any future questions, you can contact the Risk Management Advice Line either by phone, email, or visit us online at tdicinsurance.com. And we also encourage you to stay connected with the California Dental Association and the Dentist Insurance Company for support and guidance during this crisis and beyond. Visit CDA and TDIC on Twitter, Facebook, LinkedIn, Instagram for the latest updates. Thank you for attending this risk management lecture from TDIC. We appreciate your participation and hope you found this session to be informative. Myself and the speakers will now sign off. I will turn things over back to Dr. Hart. Good night and stay well.
Thank you very much for joining us, and hope you found this information helpful. I can speak for my 35 years plus on peer review. This is really good information and really helpful, because it sure would have helped many years that I was on peer review. So I can't tell you how super valuable it was. So hopefully you got something out of it. Since peer review, it seems to be sunsetted, hopefully not forever, but we'll have to see. I'm hoping not. This meeting was recorded, as you might see. I do see it on my iPad now, and will be emailed and posted on our San Mateo County Dental Society Facebook page. Stay safe out there and enjoy the rest of your evening. Thanks again for joining us. Good night now.